statutory or other defense? Yes, you have one. Yes, just the accused person.
Yes, Mary, so that my learned senior can be able to also respond to both issues, including what I'm going to ask. My lady, it has been brought to my attention that learned counsel, Mr. Mugor, who is now senior counsel, we must appreciate, we must congratulate, was appointed as a public prosecutor on the 16th day of January 2019 by Gazette Notice number 350. Was appointed as a public prosecutor for 2 years from the 16th day of January 2019 via Gazette Notice number 350 from 2019, January 16th. 16th of January 2019, yes, this year, for a period of 2 years. So we are looking until 2021, probably. And at this particular moment, he also now wants to be the, or he is the lawyer for the accused person in this case. Him being a public prosecutor, isn't this then an issue of conflict of interest? Can he work for the government at this particular moment and also work for the defense? So that the issue of representation for the accused person.
Accused. She had previously requested to be released on bail for the time being in order to protect her possessions, in their own words, for fear that the police are also after the assets. Research leader George Kinoti, it means, translated it means investigator, already described this as ridiculous, but at the same time indicated that the detained woman appropriated part of the inheritance. And then they quote him, "Somebody found guilty of murder can never inherit the murdered person," he explained Kenyan law. But apart from that, somebody who has his partner murdered and then dumps it in a septic tank should never succeed at all, says Kinoti. This is after the order. You can see that the person who has lost control of his mouth, who no longer has any regard for court orders, is the DCI of the Republic of Kenya. And it also shows that the real issue here of denying our client bail is about the DCI seeking to hand over the matrimonial home of the accused to the gentleman here called Bernard Cohen and his sister Gabri Van Straten.
Yes,
I am actually pointing out that the real issue here. No, I was talking about content, just content, the people who are guilty. And then secondly, there is a state counsel called J.V. Owiti, isn't it?
He's not around.
He's not around, but he's a state counsel.
We don't know someone like that.
There is a state counsel called J.V. Otieno who was here in the proceedings before Justice Kariuki. Yes, before Justice Kariuki. And 2 days ago, he decided he was an academic and he wrote a treatise on a murderer cannot inherit from the deceased whom he or she killed. This is published on social media. And at paragraph 1, paragraph 2, paragraph 3, paragraph 4, paragraph 5, he liberally refers to this case and the Cohens. And finally, I just go to the last paragraph. I am persuaded with the second possibility, and I think it will carry the day. Sarah may end up losing everything from the matrimonial property and or Cohen's estate. I rest. What am I saying? it is the prosecution. He is a prosecutor. I am not a prosecutor. He is the prosecutor. They are urging their case in the media. They are urging to the prejudice of our client on the merits of the case. So it is they who are out of control. So I am requesting, therefore I conclude by saying the issue of content, if at all, should be canvassed by way of a formal application to which we shall respond. The issue of my capacity to be both a prosecutor and a defense counsel, I am happy to entertain or respond to that application, including giving an affidavit on how many times I've met Nurdin Haji as a defense counsel on this and other or not on this matter, but on other matters, and then it shall be attended to. In the meantime, Your Ladyship, before Her Ladyship Justice Jessie Lesit, on the 16th of September, is it 16th or 18th? Are you sure? This looks like 18th. 16th, eh? Yes, on the 16th of September, the court listened to the parties, found that the accused had still not been subjected to a mental assessment on fitness to stand trial, and ordered, we were made an application for bail orally. We were ordered to file and serve the application for bail. We did so on the same day, filed it and served it. Yesterday, we were served with a replying affidavit from the so-called victims, represented by my learned friend, Mr. Mbeta. 2 affidavits.
My lady,
In
with all
ready-
due respect to my learned friend, he's supposed to be responding to our 2 main issues. That and the same shall be done also in the course of filing a formal application in regard to the issues of contempt of court. And my lady, as I sit, I'll also be praying that this court does again confirm or request all parties again to comply with the order of 16th September 2019, even after today's proceedings. That is all. Oh, sorry, my lady, there's one issue on the affidavits on bail. My lady, the reason why the prosecution has not filed its affidavit, we have written a letter to the Witness Protection Services or agency requesting to have some of our witness placed under protection. The communication and the content of the letter again is confidential, so as not to reveal who we have requested. And my lady, based on that, we will then be able to put our affidavit, and we intend to annex their statements, redacted statements, to confirm that the accused, all through her agents, have been interfering with the witnesses. So without that, without them having first been placed under protection, we will not be in a position to prove that, which is very vital to our role. Because we don't have OB reports confirming the same. So we are praying that the plea be deferred until the issues of contempt and representation are dealt with. And in the same time, we are given time to have our witnesses under protection who are key and vital to prove compelling reasons as to why the accused person should not be released on bail or bond. That is all.
Yes. My lady, I've seen a letter by Mr. Mugor, Senior Counsel, on 7th of March 2019, is resigning as a public prosecutor.
Perhaps I should tell my learned friend I am not yet a senior counsel, but I'm senior.
You can see my
senior to him.
You can see my prayer is good.
Thank you.
I'm wishing you well, my brother. Yes, and my lady, the question would be then, is this letter by itself conclusive that he's no longer prosecutor? Can a letter for resignation revoke a gazette notice? When counsel says that waiting for this revocation would make him to be a slave, with due respect, I think that is it's mischievous and does not have any tenability in law. And that position has got a remedy. If Mr. Haji, the DPP, has refused to regazette him or has not done so, then these courts have a judicial revision section. He can walk there and go for mandamus. If that still is the position, he then feels aggrieved, and he is aggrieved at this particular moment, then he needs to go to the JR division. But still, that question of who he is in this court today, apart from being a defense counsel in this matter, we know him as a public prosecutor. That one out there again is an issue. And it is important because why? In a murder trial, representation is everything. It is everything. So let us not take it lightly, like he is doing. Let him not say it's a sideshow, because this is a key issue. We don't want to remain with egg on our face. This is a preliminary issue that must be decided and canvassed, so that none of us is embarrassed at the end of the day. Not him, not any of us. This position must be clarified before he even takes plea for the client, because if the client takes plea at this particular moment without this issue, then is she represented? Then aren't we now going against the law? It's a serious issue. You cannot, please.
I
cannot
think
respond.
I will leave. Your Ladyship.
Cannot.
Yes. No, I'm not responding to Mr. Mbete. I'm responding to Ms. Moniki. She has made a new application. Yes, she has made a new application. She has now conceded that she will file a contempt application.
It's not new application, my lady. It's what he requested of us, and we are confirming that we will then file a formal application. So that is not a new application. I think he needs to be very clear.
Your Ladyship, if I may explain.
I'll give you a minute, Mr. Mugor.
Yes.
But just not go back on the issue.
I'm not going back on the issues.
Be brief on what you think has been doing in this.
Your Ladyship, thank you. Ms. Moniki started by saying they have committed contempt, sentence them for contempt. Right away, without defending themselves or anything. Just find it as a matter of fact. Now she has accepted that she will file a formal application. So effectively, she has abandoned the oral application. That is gracious on her part. On the part of whether or not I am a public prosecutor, she has stated in no uncertain terms that she needs to seek some instructions on that matter. And I think the final position on whether or not I am will come from Nurdin Haji, and we'll expect his affidavit in that regard. So what Ombete is asking, they are good questions because he's in the dark, but it is a matter that will come from the DPP's office. So what am I saying? Even that now, should come in the form of a formal application, and we shall respond.
My lady, just to clarify, we just said I need to confirm whether he has been revoked, whether the Gazette notice has been revoked. Those are the only instructions I need. The DPP will not file any affidavit. It is I to go and seek or to find out whether there has been a revocation of that Gazette notice.
So, how she does it, I will leave it to her. I don't wish to. I know Mr. Haji does not like coming to court, so we'll leave it there. I don't want
My
to say
lady,
more.
with all due respect to Mr. Mugor, he has he has adversely mentioned, yes, my lady, protect the officers. He has adversely mentioned the DCI's name. He's not going to the DPP. Yes, thank you. Thank you.
So, the final part, which is most important, her position has now mutated and she has made a new application. A new application, to which I am now responding, is that can the plea be deferred? She was now explaining why she hasn't done her affidavit, witness protection and all these other things. And so she's saying, can the plea be deferred to enable her to do all that? So I want
No,
to
my lady,
Unless I will get a
Mr. Mugor
chance.
is not getting to a point that I will need the court's intervention. I say that the plea be deferred for us to ensure representation and content, that those two issues are dealt with. And please, my lady, I'm praying that Mr. Mugor, being an officer of this court, does respect everyone in this court and the proceedings of this court, and he needs to be truthful.
You understood where she's coming?
I don't take orders from her, but I was saying,
That is true, but
yes.
you understood where she's coming from?
If she hears my next, what I want to tell the court, she will understand what I'm saying. I am saying it started out with contempt, then it became capacity, and then in her reply, she now said, we're going to do all that, but now do not take the plea. That is the part I believe I have a right to reply to, which is why.
You know from where I stand and from where I sit,
Yes.
there are times when you afford to really have that movement, because the nature of where you are studying and where she is, that heated.
There's no heat, Your Lordship, on my side at least.
Let me tell you how I understand her.
Yes.
You-
Yes.
I'm
May I sit
requesting
down?
you to understand her.
Yeah.
I'm understanding her to say the request for deferment of the plea taking is for her to confirm your position, whether as a public prosecutor and whether you are
Yes.
That bit is the one I want to reply to. Yes. Because it wasn't put out in front. In the front, she said contempt and capacity. So I am now responding to the issue whether plea can be deferred in order for her to file her application. I would like to point out that the record will show that the accused has been in custody for 30 days from the date she was arrested.
My lady, aren't
I
there
am-
new issues? He's just supposed to be talking about representation.
I'm not asking for bail.
Those are new issues that she's been in custody for those days. We'll need to respond to that. The question is he rightful in court as a defense counsel? Can he represent her? Does he have audience? And that's what we are saying. Can this issue first we be given time to address this issue? That's all he needs to respond to. And without him giving us any proof for us to, so that we may not seek more time and deal with this issue right now, it's in the best interest that all of us be given time to respond to that. Or he was given time to
I'm
bring
trying to
evidence.
answer that. Your Ladyship, please, if I may just, not too big, if you just hear my argument. I'm not applying for bail in that sense, which is what she thinks I'm doing. This case is not about me, and it is certainly not about her. It is about this lady here. It is her whose rights we are talking about. So, I am saying, she has already been in custody for 30 days. And I'm now coming to the issue of, if they want to have those other matters dealt with before, they should be mindful of the fact that she has been denied her liberty for 30 days. Initially, for mental assessment, which is not her problem, it is the problem of the state.
Then, by reason of the fact that it was the vacation and so on and so forth, so I am now coming to the fact that should they wish to have those other matters canvassed first, I ask the court to ask them to file their contempt application in the next 2 hours, and so that we come back at 2:30 to deal with those issues, so that the matter of the constitutional rights of this lady here are dealt with as soon as possible. I am not the only advocate in Kenya. I have been in these proceedings several times without any objection from my sister, Ms. Mwaniki, my learned sister, not my prosecution sister. My learned sister, as advocates I refer to her that. I am saying we have been here, no one has objected, and I'm just saying let's not forget we are here because of the accused. So if we can deal with those applications within the, they can file their application this morning, we'll respond in the afternoon. I'm ready because my facts are clear, and we can deal with them as soon as possible. It is the accused that we are here for. It is her who needs to take her plea. It is her who needs her application dealt with. I may also say one more thing. After 30 days, issues of witness protection should have been dealt with. If at all there are such witnesses. We have never seen them.
Ms. Mwaniki, if this court were to, because I understood you to mean you need to confirm Mr. Mugor's position.
Yes.
And for that meaning, you want to check whether the letter, taking your issue together with Mr. Letters issue, whether what is being gazetting or the letter of resignation.
My lady, yes.
How long, if I were to allow you, how long would that take?
My lady, because we also need, and what is more important, even the burden also shifts to him to show whether he's been degazetted. We will need about next week. We come back next week to confirm. Today is Thursday. My lady, to confirm. Because we need to confirm whether he's been degazetted. And if he's not been degazetted, my lady, someone else can stand in for him. He doesn't need to appear on behalf of the accused person.
All right. Allow me to make a ruling in order to see what
Yes.
You directed that we shall put in affidavits. I think you're asking my colleague whether she has put in an affidavit, not whether or not she wants to submit from the bar. It was just a simple question whether she has put in her affidavit, because if she hasn't, she can't give evidence from the bar.
My lady, we just needed, and that's the information we needed to confirm, that this gazette notice has not been revoked. We are in the process of starting the said revocation. We will be sending the said documents to the Honorable Attorney General. And that's what we needed to confirm, that this gazette notice dated 15th January 2019 has not been revoked, and the appointment has not been revoked. But we are in the process of starting the same.
Yes, but you hear what Mr. Mugor is saying, that when we left court last on 26th, the parties were to put in affidavits.
Yes, my lady.
And the order specific says you put in yours by Friday last week and defense by end of yesterday. I think that's what he's saying you are not responding to.
Yes, my lady, but because this was just the information that we needed to give the court, and this information is within my learned friend's, I mean, he's aware of this fact that we have not revoked the same.
Yes.
And that's basically what we needed to confirm. And the affidavit would have stated the same, and my learned friend again knows that we have not revoked this appointment.
Just before you, do you have anything to say, Mr. Ambet?
My lady, this is the issue that I raised initially. And it is important that that issue be resolved. reason why I'm saying this is, if this Gazette notice has not been revoked, then what are we saying? We are saying that Mr. Mugor is still a public prosecutor. If he is a public prosecutor, then he cannot continue appearing for the accused person. So I'd be saying then, he needs to at least step aside for a moment. I don't know whether step aside can be an applicable word here, but generally that's what it should mean. Until that issue of revocation has come about. Because if he has no proof of revocation,
again, I'm sorry, I have to object to my learned friend. Your ladyship directed that this would be by way of affidavit. My learned friend could raise the objection on his feet as he did on that day, but after I filed my affidavit and served it on him, the evidence should be by way of affidavits. Otherwise, there will be total disorder in these proceedings. My learned friend raised this objection. Our DPP colleagues said they will come back with an affidavit. Neither have responded to our affidavit. I think there should be some order.
my lady, the order was specific. It was the defense and the prosecution. I raised the issue, whereby both of them needed to respond. By any standard, I was not even asked to put an affidavit. But my point still stands. Please, counsel, let me just say it.
Proceed.
If he has no revocation, we do not want to end up with a mistrial here, because the family here is waiting for this matter to proceed to the end. And this is something, we cannot even call it a technicality. It is a very important issue. He needs to have cleared that dust, first of all, from him. After he has dusted himself, then he can come back. He has people in his office who in the meantime can hold fort. Let him not try to push me aside by just saying that I needed to respond by an affidavit. The question is, that is a fact. It is a Gazette notice. Let him be revoked by a Gazette notice, or let him show us that it has been done. Then that way, we'll know he's not a state official. Maybe he's a mole.
Your Ladyship, this is a very serious matter involving the liberty of a citizen who has now been held in custody for over 35 days. In circumstances that now amount to detention without trial. As I said before, it's not about me, it's not about the prosecutor. I filed, to be specific, an affidavit as directed by you. And in the affidavit I filed, at page 20, is the Gazette notice to which Ms. Maniki has referred. It's actually found at page 18 and 20. And I had put on record my letter of resignation dated 7th March, but for good order, and that the one I had placed on record was not the stamped copy, it was the extra copy on file. At page 13 of the affidavit, next just to the affidavit, I have now enclosed a resignation letter by myself, addressed to Nordin Haji, OGW, resigning with immediate effect. I have stated in my affidavit, therefore, that 7th March 2019 at 2:55 p.m. I ceased to be public prosecutor. I have had acknowledgement of this fact by the DPP himself. even after we left this case, I resent it to him by WhatsApp, and he told me it is okay. I can show that WhatsApp from Mr. Haji himself. But Ms. Catherine Mwaniki and I, at that time, were dealing with a specific file.
My lady,
It's on the it's in
so
the
my
affidavit.
learned friend is going through his affidavit, and the reason why we did not even respond to this affidavit, my lady, is because he was also dwelling on issues that you were going to give directions today. So we were waiting for those directions. The question that needs to be answered is, pursuant to the Gazette notice appointing him as a public prosecutor, has it then been revoked? And it is revoked pursuant to another Gazette notice. And I am saying that we are in the process of doing the same, sending the said documents or request to the Honorable Attorney General. If my learned friend has any Gazette notice of revocation, then he can give. But the question is, has this Gazette notice dated 15th of January 2019 been revoked? My answer is no.
All right.
With great respect to my learned sister, that is her argument. Can I just finish what I was saying?
Yes, just
She will respond.
finish. What you do, I read the affidavit,
Okay.
and I know it also has issues on contempt. So if you can leave out anything to do with the
dealing
contempt of
that-
court and deal with the issues of your being appointed and resigning, then we are good. Then I'll be able to give you the ruling, and then we give directions.
Actually, the issue of contempt will come later.
Yes.
At page 66, Catherine Mwaniki and I were dealing with a particular file called Supreme Court Appeal number 8 of 2018. And she had forwarded to me a file for my perusal. The letter is here. The letter is here. But let me go to page 66. Following my resignation on the 7th, I wrote to Mr. Haji, Supreme Court Appeal number 8 of 2018. And my second paragraph of that letter, I said, following my resignation as a public prosecutor on 7th March 2019, I enclosed herewith your complete bundle of documents as forwarded for your attention. And Mr. Haji replied, page 67, through the hand of CM Mwaniki, I believe is, who is my colleague who is in court today.
Are in collusion with politicians. What I see from the photograph, my lady, of the bereaved family.
And I need to just alert you that I think I didn't go further with that photograph issue. He didn't say much after I brought to the attention that your objection. So you may need to just
Yes, my
bring
lady,
it down
and
a bit.
I still stand that he needs to substantiate and provide evidence that we are in collusion with politicians. My lady, let it not be forgotten that we are here because a person lost his life or his life was taken away from him. My lady, it is also unfound, and again with due respect to my learned friend, as a former DPP, he knows that bail is not absolute, and it is not correct to say that the accused person is being held in detention without any basis.
Can we leave that to when we get to the bail issue?
Yes.
Yes.
My lady, that came out from him that the accused person is being kept in detention without any basis. My lady, it is not I who raised the objection. The record stands clear. Counsels for the victims,
The objection in respect to
in respect to the standing or whether Mr. Mugor is still a public prosecutor, was raised by Mr. Umbeto, watching brief photo Cohen's family. My lady, again I respond that due process needs to be followed. We have not revoked the said Gazette notice or his appointment. We are in the process, and we will forward the requisite documents or request to the Honorable Attorney General. Again, I submit my learned friend, being a former DPP, knows the process. And unless he has a copy of any gazette notice for revocation, we will be asking him to table before this court. But we submit that the same has not been done. No evidence that any person is being forced or coerced, or there's any forced labor or slavery. All we say is that the due process needs to be followed. And I'm glad my learned friend has stated, and he's aware as a former DPP, that for officers within the Office of the Director of Public Prosecutions do not need practicing certificates to appear before this court. And I'm glad he has noted that. And my lady, my role was very simple. As much as we have received his letter of resignation, due process needs to be followed. He needs to give us that opportunity to do the same. And I have said that we have started the process once the said objection was raised. And my learned friend again knows the earliest the gazette notices come out on Fridays. And we ask the court to take note of this position. That is all.
Is put in a position of slavery. But he chooses to continue being in that position by himself. He does not move out of that position by even trying to attempt to be gazetted. He does not do it. So he keeps quiet and hopes this court can defend him. He chooses that position and he still cries foul here. You have been told that this raising of the issue of his standing was an afterthought. What exactly is afterthought? Because at the time I raised it was the earliest opportunity, and it was my second day in the court. So while I was sharp at it, he was asleep. But I've seen his affidavit, my lady. And in paragraph number 3, one of the things he raises is that there is a conspiracy. And this is one of the things that he has said. There is a conspiracy between the DPP, the DCI, and myself. He mentions it. My lady, let me just say this. When we started practice all these years, by the time I was starting, Mugor was in a position that we admired, and you know, he was our hero. But it is also good when it says, some of the things are that it is not good to meet your heroes, sometimes they disappoint you. So when he says these things about me, and a conspiracy, yet I'm the one who's raised that issue. It embarrasses me, and I'm disappointed in it. But then the question is, has he answered the question that we asked? That was the question, whether his standing is here, whether it is proper. Has he brought to you any authority that says that you can revoke a gazette notice by the authority he's trying to show us, or by a resignation letter? Because we know how you go by to revoke a gazette notice. You degazette it. That one he has not shown this court, and that puts him in the same position of being a prosecutor. Then can he defend? But then he comes to you and he's trying to tell you that, does it matter? Your Honor, it matters. Let him not simplify it. The reason why this court rose the other time was for him to be able to confirm this position. But it brings an affidavit and attaches so many things, but does not answer that particular question, whether he can be able to stand here by only a resignation letter. Because a gazette notice, Your Honor, is something that is made so that it is into the public. So he resigns in private and now tells you that he spoke with Nordin on a SMS, on a WhatsApp. I don't even know which one really exactly. But where does that leave us, the family? We do not know about those issues. He has not even attached that message. So he still wants an apology, not today, not ever, until the day we have that gazette notice showing that he has been now degazetted. Yes, the accused person has been in custody. She might have been in custody for all these days. She has her rights, yes? Do we have our rights? Does the family have its rights? And if so, can they be ignored? And the moment we find ourselves having proceeded with this matter, and I keep on repeating this point, Your Honor, we proceed with this matter, then we realize that we had not tackled this issue before. All of us then will be embarrassed by it. And when counsel then comes and tells you that we should now fight this case on merits, and that we want him to bring maybe a lawyer who that we can maybe bully, we are not even afraid of him yet. And we like a good fight. For me, I like a good fight, and I'll fight him to the merits of the case. So that popular Swahili saying that says, kwa ground vitu ni different, then applies.
Sasa wanataka nitoke. But having said that, that's really like Your Ladyship, the only issue that warrants my response is the fact that the gazette notice, if at all Catherine Moniki is to be believed, we were here on Thursday. If it was an oversight on their part, and they think it is the law, if the next day was Friday, it just shows that the intention is to continue to sustain an unsustainable argument. The other issue is she is not the appointing authority for public prosecutors. Only Nordin Haji could have responded to the objection. Finally, it was not me to prove that they had done their steps, whatever they call them. That was for the DPP to do so. For me, I only had to show that I had resigned on the 7th of March at 2:55 p.m. in a letter I delivered personally to the DPP's office. That's all I have shown. The Kenya Gazette is to notify the public. That does not change the fact that I have resigned. And they are free to re-engage me. If you read that letter, I have said, maybe it's important, if you ever want to engage me again, do it on a case-by-case basis, on terms that I agree to. We have since had a cup of tea with Nordin Haji, and he said when that day comes, when he needs my seniority and experience, he shall approach me. So for now, I am just the defense counsel, representing Sarah Wairimu. One last point. Taking a plea, considering bail, does not go to the merits of a case. The accused should not be held up because of their own failures want to gazette anything of any sort, it certainly doesn't hold up my life. But they may do whatever they want, but it has no bearing on whether or not I am not a public prosecutor.
Which I need to look at. What is bothering me now is what to do with the accused seated on that dock. Because I believe you standing there as a defense counsel, you are standing being questioned, requires me to make a ruling on the issues being raised today. And I'm aware there is a ruling, I'm just giving you now.
Ruling on which part?
Ruling on the issues that were canvassed on 26th. This was one of them. There was contempt issue. Yeah. So.
Were you going to read the ruling?
Yes, I'm going to. It doesn't affect what we are doing, fortunately. So now, there we are, Mr. Mugor. I need to retire and look at what you are bringing before me and give you a ruling as to your standing as a defense counsel, because that is pertinent to what the objection, or rather what is being raised by the other side. And I was asking now, are you the only partner in your firm? Because I believe from what has been canvassed from 26th to today, the issues is not the firm but you as Mr. Mugor.
Your Ladyship, you see, the point I was taking is that the accused person has chosen me to lead her defense. And to allow this to happen where she then has to reconsider her point, even if it is my partner, would be on a it would set a precedent that I think we will all live to regret, because it will be putting accused persons at the mercy of the prosecutors. And whenever they want to take advantage, they just raise an issue about a defense counsel. As of now, there is no prejudice if she takes her plea, whether or not I stand. The issue of bail, if you wanted to hear us today, if at all, that would require me to lead that discussion or that application.
Yes, because where I'm headed right now, so that we don't, the issues of her rights be kept in custody before taking the plea, is that whether another person, another partner or another associate of yours could just stand in for the plea. Other issues because I need to make a ruling on this, so that we lay all the issues in an order that can be followed in future if that need be.
So just the issue of plea?
Yeah, I was concerned about the issue. Could you consult and let us know, because I think I understand it is your being there that is being objected to.
See, Your Ladyship, it's a little, the dilemma I mean is, it's not just a question of me sitting down and
Yes.
Kala standing up and taking the plea. It will be my withdrawal from the matter, even if it is for 15 minutes. I think...
So then it means I make my ruling before we can proceed any further?
I think so. I think
right.
it's in good conscience. I think we need to prevent this type of abuse of process, so we will prefer your ruling.
Lady, can we just let you allow the court to make a ruling, because further comments will...
It's okay. I think he's just trying to emphasize. You know, everybody has got their man of that is Mr. Mugor for you.
I'm praying that,
So what I want you to do, counsel, sorry, is your client to understand 1 week for responses. Now we are talking 2 weeks. Are we not? So we are talking of the 15th of this month. We come back for mention. Okay, I'm going to be specific, gentlemen and lady, because I want that application for contempt, because I'm told they are now from all sides, on or before 8th of this month. Okay? That is filed and served on the other party, 8th of October. And responses filed and served on or before 15th of this month. All right. Now, on the matter before me, yes.
I wanted to plead with you on that other matter. If we could have a ruling on the issue of representation as early as today or tomorrow, because it is about the fundamental rights of the accused. If you determine, for example, that Mr. Philip Mugor is a public prosecutor, it needs to be done so fast. So I'm pleading, I'm imploring, there is only one affidavit before you.
I'm hearing that plea, Mr. Mugor.
Yes, if it goes, it's now an accused suffering because of a counsel, I think that now is...
I hear your plea.
And it can also go independent of the other matter. In fact, perhaps can I say that if it can be made before the 7 days are over, so that we'll file the contempt matter.
All right. Just to be clear, on the matters of contempt of court, which is in my ruling here, I say it does not affect the taking of the plea, that application. Yeah, I thought it's because that is a totally different issue. If found guilty, the sanctions are going to affect them wherever they are. So that one does not affect. So we should now be concerned with filing as given, and then I give you a date for the ruling on the matters of your standing. Considering your plea.
You said something that is very important.
Yes.
It does not affect the issue of the plea.
The fact that the contempt of court proceedings are to be filed does not affect this court taking the plea against the accused person.
And now the second part is the issue of representation.
The ruling date I'm giving you just now.
And I was asking you to bear in mind.
Yes. Which I've taken into account and said I've taken your plea on the urgency of that ruling. But I find I'm not able to give it today. I'm going to give it on Thursday. He's going to bear with me for that 2 days. That is tomorrow and the Thursday I'm giving. So ruling on the matters canvassed today will be on Thursday. That is 3rd. Okay? All right. On the same one?
Yeah, over the same file.
Miss, I thought you were a spectator.
No, it's not on record.
I'm addressing something.
No, I'm saying that because when we started, you asked, yes, totally.
You the guard orders. Because this is a matter.
Your ladyship, nothing stops
No,
it.
yeah.
I'm only notifying
Mr. Omari, I think it's within your right and their rights. If you want to give one, that's okay. I don't need to put that on record. Really. Yes. Can we now get to, there is a matter we put at midday, which is almost Mr. Omirera's matter. Can we now breathe? What? That court. I always say you keep that door open and you are not managing it. I don't know what to do.